We've been spending a lot of time on this Sergio Garcia case, where an illegal immigrant is now going to have a license to practice law in the state of California. You're a lawyer in California. Can you give us any insight as to why the California Supreme Court ruled this way and why the state government would even allow this?
I have two reactions. One, I am a partner in a law firm. Hewitt works very hard to take care of our clients. We are all professionals. We hire people that have passed bars from great law schools. We know they know the law, and we know that they're going to take care of our clients. But I'm also a law professor at the Fowler School of Law at Chapman University, and I have been since we opened the doors. Those kids are working really hard to get their law license, to work in a hyper-competitive market, to make a living in a land that required them to spend sometimes $30,000, $60,000, $90,000 to get an education. And what I saw the California Supreme Court do to them and to every lawyer in California with this decision is to say that which you earned is not as valuable as what you put into it, because we will allow people who didn't play by the rules to represent people who are going to depend upon the rule of law. I was shocked. I'm very shocked by it. And I am a proponent of immigration reform. I am not a proponent of waiving the rules, especially when they so disadvantage young people who've got an uphill climb in California when it comes to practicing law.
Well, forgetting that you and I might disagree on immigration reform, the halls of justice, yeah, the centers of the law, now lawlessness is going to be accepted in, yeah, those hallowed institutions. This seems very, very dangerous when the lawbreaker has the standing to practice the law.
Yeah, the rule of law begins with the assumption that the judge who is standing down and looking at you will expect you to fairly and completely state the law, even those cases which are injurious to your position. A lot of non-lawyers don't get that. You have to bring adverse precedent to the attention of the judge. If you are yourself a lawbreaker, how can you be expected to bring adverse precedent to the attention of the court? I don't think the Supreme Court thought this through, and I will be interested if the United States Supreme Court doesn't find some way to take a look at that ruling itself. Although the rules of the law, the Bar of California, are themselves open to the state Supreme Court to decide, there are issues which transcend federalism, and the rule of law writ large is one of them.
All right. Pencil me in to come back here and talk about this as we start to see the evolution of this precedent.
All right. Deal. Thank you.